everyone. I'm Leon Bibb with breaking developments in that 2012 Cleveland police chase and deadly shooting. Let's go live to the Cuyahoga County Justice Center. County Prosecutor Tim McGinty is at the podium.
Sherry Royster.
Dwayne Deskins.
Andy Nickel.
Adam Shalipka. James Gutierrez.
Eric Barnhill.
Ladies and gentlemen, I want to thank you for your patience. The Cuyahoga County Grand Jury today voted to indict Cleveland police officer Michael Brelo on 2 counts of manslaughter for the killing of Timothy Russell and Melissa Williams on November 29, 2012. Under the Ohio Revised Code number 2903.03, manslaughter is a felony of the first degree carrying a mandatory prison term from anywhere from 3 to 11 years depending on the judge's discretion. It also carries a 3-year gun spec, which is required to be served consecutively. Officer Brelo fired 49 shots at driver Timothy Russell and his front seat passenger, Melissa Williams. The shooting took place in the parking lot of Heritage Middle School in East Cleveland at 10:53 p.m. on that evening, following a lengthy high-speed chase that began in downtown Cleveland. Evidence shows that a total of 137 shots were fired by the Cleveland police officers in the schoolyard. Investigators also determined that the victims were unarmed. After more than 100 shots were fired at Mr. Russell's car, and its occupants obviously, it was trapped by police officers in a narrow lane and came to a full stop in that schoolyard. All officers at the scene saw fit to cease fire. Then Officer Brelo started shooting again and fired at least 15 shots, including fatal shots, downward through the windshield into the victims at close range as he stood on the hood of Mr. Russell's car. This was now a stop and shoot, no longer a chase and shoot. The law does not allow for a stop and shoot, and Officer Brelo is liable for his actions. This week, the Supreme Court of the United States of America reiterated prior case law in Plumhoff-Rickard decision, ruling that, quote, if police officers are justified in firing at a suspect in order to end a severe threat to public safety, the officers need not stop shooting until the threat has ended. However, in this 9-0 decision, unanimous, of course, written by Justice Samuel Alito, the Supreme Court of the United States went on to conclude that it would be a different, quote, it would be a different case if the police officers initiated a second round of shots after initial round had clearly incapacitated the suspect and ended any threat of continued flight. Let's be clear what happened here. The car was fully stopped. Escape was no longer even a remote possibility. The flight was over. The public was no longer in danger because the car was surrounded by police cars and entrapped, and 23 officers in a schoolyard safely removed from pedestrians and traffic. The primary danger facing the police at this time was themselves if they continued to shoot at each other in the circular firing squad they had inadvertently formed. After a short ceasefire, Officer Brelo unleashed an unlawful second barrage of shots for which he is indicted. The ultimate legal issue here is whether the police officer was justified when he stood on the hood of Mr. Russell's car and emptied his clip into the occupants after the chance of flight was completely eliminated and the citizens no longer presented a threat to the public safety. The officer was not, and he has been indicted as a result by the Cuyahoga County Grand Jury. In addition to the charges against Officer Brelo, the grand jury also indicted Lieutenant Paul Wilson, Sergeant Patricia Coleman, Sergeant Randolph Daly, Sergeant Michael Dunnigan, and Sergeant Jason Edens, each on 2 misdemeanor counts of dereliction of duty. These 5 supervisors abdicated their leadership responsibilities during this 20-mile, 22-minute high-speed chase that involved at least 62 police cars and more than 100 officers. These supervisors failed to do their duty to control and manage the chase and thereby endangered both the public and the police officers they were supposed to be leading. Many supervisors in other sectors followed the law and followed the rules and completed their duty and management properly. These indicted did not. These supervisors allowed, and actively allowed, they were actively involved in this chase in some, allowed a disturbed petty criminal to take charge of and lead a large portion of the Cleveland police force that was on duty that evening, and to unnecessarily endanger motorists and citizens in 2 cities. Mr. Russell led a long parade of police cars, as you have seen from the many film clips that have been released by the media, through 76 traffic lights and stop signs, 141 three-way intersections, 71 four-way intersections, with speeds up to 110 miles an hour between the hours of 10:30 and 10:53 at night, when the roads are active and people are many. Only through the grace of God were no motorists, pedestrians, or police officers injured or killed in the chase, or by the crossfire or friendly fire at the school that the police inflicted upon themselves. The supervisors charged today ignored the policies of the police department to conduct chases in a manner that shows, quote, due regard for the safety, end quote, of the public. They ignored their own training. They put the public at risk. They put the officers under their command at risk. I'm here also to inform you that the grand jury no-billed murder charges on Officer Breedlove that we had sought. Based on the law, we, the county prosecutor's office, did not recommend that the grand jury seek charges against any of the other 12 officers who were at the school that night who took part in the initial barrage of shots upon the car, for obvious reasons that we've discussed in the case law already. The task of reconstructing the events of November 29th was made far more difficult because Cleveland police cars are not equipped with video cameras. Dash cams would have made the facts far easier to discern and would have had a very positive effect, I believe, on the officers themselves. The dash cams were of great assistance in last year's justifiable Solon police shooting, and also in the Memphis police case that the U.S. Supreme Court addressed this week and I alluded to earlier. The cost of investigating the shooting by the Attorney General, Cleveland Police Department, grand jury, sheriff, and other agencies and experts employed will exceed, I am confident, the cost of purchasing dash cams. We strongly urge the legislation pending to proceed and that become a reality. This will be a safer city for it. The training that is already begun and taking place by the police department and other departments, so this history doesn't repeat itself. Let me emphasize that today's indictment is not an indictment of the more than 1,500 Cleveland police officers who serve and protect our community. That department has a long and distinguished history of service and bravery to our community. These men and women have a dangerous job, and every time they report for duty, they are required to put their lives on the line. No one respects or admires the work of dedicated professional police officers more than a prosecutor. They are our heroes, but they too must answer to the law if they break the law. The city of Cleveland has already taken initial steps to assure this kind of tragedy does not reoccur. We hope this prosecution serves justice and also serves that same purpose of preventing future errors such as this. In closing, I want to thank the men and women of the Ohio Attorney General's Office, the Bureau of Criminal Investigation, the Cuyahoga County Sheriff and the Cuyahoga County Sheriff's Detectives, the Cuyahoga County Medical Examiner's Office, the East Cleveland Police Department, as well as outside scientific and legal expert who help us understand the events of November 29, 2012 and gather and test the evidence. Their work has been invaluable to this investigation and in the long run to this community. Today's indictments are not the end of this process. They are the beginning of a legal process. Under the Constitution, those charged enjoy a presumption of innocence. They have a right to a vigorous defense and a trial by jury of their peers, and that jury will make the final decision on their guilt or innocence. We appreciate your patience. We thank you for your understanding, and I wish you all a good weekend. We'll have no further comment at this time, but we will endeavor to answer your questions. When you put them to Joe Froelich in writing, we'll respond in kind if we are able. As this is a pending case, I have to take that response. Thank you very much.
Cuyahoga